Appellate family court litigation is complicated, it can be confusing, and even to seasoned practitioners such as myself, the results are not always straightforward. Thank you, everybody, for joining me on another episode of my series about interesting appellate legal issues. I'm going to take a little more of a deep dive today, looking at a very recent decision from the Appellate Division in Brooklyn, which is called the Second Judicial Department, that was issued on February 18th, 2026, in a case called Dionis F versus Daniela Z. Anybody who wants to actually read this decision, please contact me by email or on phone or text, and I'll send it over to you. In order to understand what the Second Department did in Dionis F versus Danielle Z, you need to go back to a prior decision of the same court on July 17th, 2024. And what we learned there is that the litigants are parents of a child. And back in 2021, the mother filed a petition for custody. The father filed a cross petition for parental access, and the parties arrived at a stipulation of settlement back on June 22nd, 2023. It provided for certain specified access to the father and the potential for an expansion of the father's parenting time at a later date. The parties apparently resolved this with or without lawyers, but there was no further involvement by their lawyers, and the only person who brought this case to the attention of the appellate court was the child's attorney. Now, this is a fairly new phenomenon that a child's attorney has an independent basis, not really a right, an independent legal basis or authority to litigate an appeal. And that was decided probably about 5 years ago. But in this case, it's not questioned that for a custody litigation where the attorney for the child, or AFC, believes that there's a problem meriting a reversal or modification on appeal, that attorney can go forward and litigate the appeal, even though the parents have fully resolved the case. So back on July 17th, 2024, the Appellate Division said, no, parents, it's great that you guys have worked this out. It's great that family court ratified the settlement of custody and parenting access, but the family court should have interviewed the child before ordering visitation that would be, in some senses, therapeutic or supervised. It wasn't really clear. Supervised and therapeutic parental access. And it left open a number of questions. So the appellate court sent the case back to family court for something called a Lincoln hearing, so that family court could find out what the precise concerns and feelings were of the subject child. Now, that Lincoln hearing is a very common occurrence. So to that extent, the attorney for the child was successful. Mind you, the attorney for the child was antagonistic to the father, both in 2024, when this case was at the appellate court, and again in 2026. The attorney for the child said that the child feared and hated his father, had concerns about the father's lifestyle, and had strong wishes not to have any parental access with his father. So the case was reversed and sent back. Now remember, we had an order here June 22nd, 2023. The child's age is not provided here, but let's assume that this is a child who's old enough to verbalize his opinion. So let's say he was 10 years old in 2021 when the mother filed her petition. He was 12 years old in June of 2023, roughly, when the party settled it. for this order of custody and supervised and therapeutic parental access to the father. And now in 2026, the child is about 16 years of age, 15 years of age at least. You see where I'm going with this. This is just a very, very slow, drawn out process. What's amazing is in the most recent decision dated February 18th, 2026, the Appellate Division in Albany, that same court affirmed the underlying order that the parents had entered back in 2023, same exact stipulation of settlement, and found that the court's determination with respect to the father's parental access had a sound and substantial basis in the record and will not be disturbed. The reason I find this just extraordinary is because, no disrespect to the attorney for the child, who was the only appellant on both of these cases, it's obvious that there were some facts that could not be discussed in a public fashion, particularly on appeal, that had somehow left this family in a situation where everybody was getting what they wanted. And you may say, well, that's exactly what they had back in 2023 when the parents walked into family court with a settlement. We just don't know. What we do know is that after the reversal of that stipulation in July of 2024, the original family court judge got to interview the child and find out how the child was doing, his feelings, preferences, and concerns. And then, based on the information in that confidential interview, which is sealed and not shared with the parties or their lawyers, the court went back to the 2023 settlement and said, good for you, parents. You're working in the right direction. And now, on a second review in February of 2026, the Appellate Division agreed. Look, I was an attorney for child for over 10 years in Westchester County, and I continue to have work in the family courts and on appeal in cases involving custody and visitation where there's an attorney for the child. The attorney for the child is not a white knight who gets to resolve cases and tell the court what it must do. The job of the attorney for the child is simply to articulate what the child wants and to fight for an outcome that is consistent with what the child has told the attorney. I have no idea how this case dragged on so long. I'm sure that the parents are relieved that it's over, and I'm sure that this kind of problem will recur. So that's just today's little deep dive into an interesting appellate issue that I wanted to share with you. We covered custody and visitation. We talked a little bit about the role of the attorney for the child, and we also talked about the struggles of timeliness and how a case like this one took 5 years from the initial petition in 2021 to what I would believe now to be the final resolution in 2026, when the child is obviously much older. Thank you very much for stopping by. Please click the like and subscribe buttons on my YouTube channel and check back the next time I have a video to share with you. Good night.